Good morning, everyone, and thank you for joining us. My name is Jason Cogdell. I'm one of two benefits attorneys for ProBenefits, and I'm here with Chris McCauley, my colleague, and on behalf of Chris and myself and the rest of the ProBenefits team, thank you for joining us for today's Attendee Choice webinar. And as many of you know, we sent out a webinar survey a couple of weeks ago allowing you to vote on the topic for this webinar, and what was chosen with almost a third of the vote is the ERISA Plan Administrator, what employers need to know. So this is a mini webinar session. It won't last long today, but we want to provide you some practical advice about who the Plan Administrator is for your group-sponsored plan subject to ERISA, and some details about what you need to know about that role, including the basic responsibilities, liability, common mistakes to avoid, and Chris is going to walk you through that. Thanks to everyone who responded to our survey. We had a great response. We gave away 5 Amazon gift cards that were randomly drawn from those who responded. This is the winning topic, and this is what we're presenting today. Our next webinar, by the way, is September 20th, and we're going to do an update on ERISA and specifically SPDs, what employers need to know about plan, summary plan descriptions, SPDs. We have listened to your feedback for other topics of interest, and we will be reconfiguring our webinar schedule for the rest of the year to address some topics, including the second highest vote getter was the ACA guided quiz on player pay, and I'm going to be conducting that in October. As always, your questions are welcome. You can submit them through the question box during the session, and we'll get to them during or after the session, or you can send an email to Chris, and we'll be happy to respond to that. With that, Chris.
Thanks, Jason, and again, welcome to everyone who is attending today's presentation. The topic today was born out of some common questions we receive when we're setting up FSA plans, HRA plans, or if we're going to draft a WRAP SPD for a plan. One of the questions we always ask at setup is, who is the plan administrator? And often we receive questions back. Well, I don't know who the plan administrator is for our plan, or who should the plan administrator be? What does the plan administrator do? And so out of those questions, we thought that today's topic about plan administrator, or having a short presentation on the topic, would be helpful to all of you, especially since many of you that are listening today likely are the plan administrators for your plans. So with that quick intro, I wanted to quickly take a look at potential ERISA plans that your employer is offering. It's important to know what plans are subject to ERISA, so you know whether you have to comply with ERISA or not. I'm not going to go into detail about all of these plans. We've talked in detail about them in previous ERISA presentations, but I just wanted to give this quick list so that you have an idea of what plans are potentially subject to ERISA. This is not an exhaustive list, so there potentially are other plans subject to ERISA. But when thinking about ERISA compliance, these are the main plans that are likely subject to ERISA. Moving on, I also wanted to give a quick 10,000-foot overview of ERISA compliance generally. These are the main components of ERISA compliance. We've talked about them, some of them in depth on previous presentations, including the Form 5500 reporting requirements, and also the plan document and SPD requirements, as well as COBRA. But again, this is just a broad view of ERISA compliance so that you have an idea of what we are talking about today with respect to the plan administrator and what responsibilities and areas of ERISA compliance the plan administrator has.
Chris, relative to that word fiduciary, you know that fiduciary is a word that is sometimes intimidating to us as individuals. Can you just speak to that word and whether fiduciary and plan administrator are synonymous?
Yes. In short, we're going to talk briefly in future slides about the fiduciary responsibility. In short, what the fiduciary responsibility means is that the individual must act in the best interests of the plan, and the decisions they make must be in the best interest of the plan and plan participants. Plan administrator is almost always a fiduciary of the plan. They may not be the only fiduciary. There may be other fiduciaries within the employer organization that have responsibilities with respect to the plan, but the plan administrator is almost definitely a plan fiduciary for all ERISA plans. And with that, the first question is always, who is the ERISA plan administrator? And simply, the ERISA plan administrator is the individual, corporation, association, or other entity that's identified in the plan documents as the plan administrator. So it doesn't have to be an individual. It can be an individual. It could be the employer, plan sponsor. It can be a committee. So there are options in terms of who is the plan administrator. If no plan administrator is identified in the plan documents, then the employer plan sponsor is the administrator by default. And then the question, we often receive the question as to who should be designated as the plan administrator. And I don't think there's one great answer for all employers. It depends on your organization and the people that are administering the plan or are part of the plan and their particular situation. The employer plan sponsor is one option to be designated as the plan administrator. One of the pros for designating the employer is some flexibility. If an individual leaves the company, you don't have to get a new plan administrator. You don't have to adjust your plan documents every time the administrator leaves to include the new plan administrator in your documents. However, there is a con for designating the employer, and that's response time. Some of the decisions under ERISA need to be made within certain specific timelines, and if you are required to get the full board together, company board together to make a decision about a particular ERISA matter, then that obviously takes time, and it's easier if there's one individual that can make the decision, can make that decision quicker. So that's why some other entities may decide that an individual is better suited to have the role as plan administrator, because the decision making is more centralized. Normally it takes less time for the individual to make up their mind than a full board or a group. But the individual is another option. The one downside with having an individual as the plan administrator is that the plan administrator needs to be listed in the plan documents. If that individual retires or leaves employment, then you have to have a formal plan amendment to provide the new individual that will hold the plan administrator role in the plan documents. And in between the employer and the individual, it is possible to designate a committee or a group of employees as the plan administrator, and that has some of the same pros and cons as designating employers or individuals. Once we decide who the plan administrator is, the question becomes, what is the plan administrator's role? And essentially, the main role of the plan administrator is to act as the final arbiter of all plan issues. For example, if there's a question as to whether an individual meets the hourly requirement for eligibility, the plan administrator would make that final decision. If there was a claims decision, if there's a question as to whether a particular claim is eligible, generally the plan administrator is the final arbiter of that question as well. If there's a question as to whether someone on leave is eligible to continue benefits, again, that's another plan issue that would be decided ultimately by the plan administrator. So that's the main responsibility of the plan administrator, is to act as the final arbiter for all plan issues.
Chris, a couple of questions. That's a good explanation. First is from an employer, if we are not sure whether we have named an individual committee or whether our organization is the formal plan administrator, where would we look to find that out and to see if we have named someone, or if not, do we need to name them?
The place to check, as I mentioned, the ERISA plan administrator is the individual identified in the plan documents, so you would start with your plan documents. Whatever, you would first look at the plan legal document and then also the SPD, your summary plan description to see if a plan administrator is named. The plan administrator is a required item that needs to be in the summary plan description, so likely if you have an SPD, the plan administrator is listed there. So that's the first place to start. If you don't have one of those, if you don't have legal documents, you obviously need them and should implement them. But if an administrator is not named in the documents, then you want to go ahead and amend those documents to include a formal designation of the plan administrator.
Well said, Chris. And a lot of folks that are on the session today are people that we've either worked with on a RAP SPD or had RAP SPD conversations. And to Chris's point, for plans that use the carrier booklet as the default SPD but have not implemented a RAP, the carrier booklet is not going to have identified a plan administrator. So it's one of the items that not only is required by ERISA but is typically not in an SPD for an employer that just has relied on the carrier booklet. You know, for instance, a small employer with a fully insured plan is just relying on the carrier booklet as the default SPD. This is something that has likely not been identified. A submitted question, Chris, for an employer that has a fully insured plan under 100, can the carrier be the formal plan administrator or not?
Generally, that's not the case. The plan administrator can often delegate certain duties to the carrier. So even though one of the ERISA compliance issues is the responsibility of the plan administrator, they could delegate that duty to the carrier, but often generally the carrier would not allow themselves to be added as the plan administrator. So practically, no, that's not really an option. The plan administrator generally needs to be an individual at the employer, plan sponsor, or the employer itself.
Yep, I agree. Another follow-up question, could the plan administrator be identified by title? So rather than naming an individual by name, could we name them by title, such as corporate treasurer or chief financial officer, so that if the individual in that role changes, the role would still be the formal plan administrator?
I think that's a possibility, although I would also recommend naming a particular individual. Just like the individuals could change, the roles at the company could also change as well. So I think it's best, if you're going to have an individual, to name that particular individual at the time that you're drafting the documents, and once that individual moves on, then to amend the documents to list another particular individual.
And also, just as a recap, you all were listening to Chris's explanation of the plan administrator's role, and I think he explained it well, but just to recap that, and Chris, I'm just reading from my notes here, the plan administrator is the one who will define eligibility, make sure people that have qualified as eligible are actually offered the plan, that the terms of the plan are followed, to handle any leave of absence issues, whether that's an FMLA leave of absence, whether it's a short-term disability leave, workman's comp, those types of leaves are going to be handled by the plan administrator. Decide any appeals of denied claims that come through. That's a key plan administrator role. One of the simple items that we consider blocking and tackling, paying the premiums to the carrier, or funding the accounts for a self-funded plan to make sure that premiums are paid. Chris, any other items of practical advice from your explanation earlier?
I think that's all for now. In addition to that role as arbiter of the plan administrator also has a number of statutory and fiduciary responsibilities that they are required to handle. And that includes 5,500 filings, which we have talked about in depth in previous presentations. 5,500s are the annual reporting to the DOL for health and welfare plans with 100 or more participants. So the plan administrator is the individual that is responsible and ultimately liable for deciding whether those 5,500s need to be filed and go ahead and filing and submitting them if required. Another responsibility that we talk about regularly in our presentations is the disclosure requirements. The plan administrator is the individual responsible for providing participants with SPDs, summary plan descriptions. If the plan is amended and summary material modifications are drafted, the SMMs also need to be distributed to plan participants. SARs are summary annual reports, which are simply a summary of the 5,500 filings. The plan administrator is also responsible for providing the SARs to plan participants after 5,500s have been filed, and then also any other document requests. If a participant requests to see the plan legal document, the plan administrator is responsible for providing that document to plan participants. COBRA responsibility that generally falls on the plan administrator. The plan administrator is the one responsible for providing the notices that are required under COBRA, so plan participants know their rights and responsibilities as it relates to continuation coverage under COBRA. And we're going to talk on the next slide that it is possible for plan administrators to delegate these responsibilities, but ultimate liability generally remains with the plan administrator. HIPAA, the plan administrator was the individual that is generally responsible for providing certificates of credible coverage, but they're no longer needed since the ACA has eliminated the pre-existing condition rule, so it's not required anymore. Another requirement is the qualified medical child support orders. If there is a judgment or a decree from a court that requires the plan to cover certain children of employees, the plan administrator is the one responsible for determining what to do, whether that support order is qualified, and whether to offer coverage to the child. There are certain record-keeping responsibilities for the plan administrator, especially as it relates to 5,500 filings, certain claims documents, and also the plan legal documents. And then in addition to those statutory responsibilities, the plan has fiduciary responsibilities as well. We talked briefly about this a couple slides ago, but the plan administrator is required to act in the exclusive benefit of plan participants. So when making plan decisions, it is important that the plan administrator consider what is in the benefit of plan participants. The plan administrator is also required to follow the terms of the plan, and also required to show prudence when making certain plan decisions as it relates to selecting providers and investing plan assets. So those are additional responsibilities that relate to the plan administrator as their position as a fiduciary as it relates to the plan.
Chris, quick question regarding the above and specifically summary plan descriptions. One of the common questions we receive, as you know, is if an employer has an SPD, let's just call it a wrap SPD, and then there's a plan change, should the employer do an SMM, summary material modifications, or just go ahead and amend the SPD to avoid a summary material modification?
From a compliance standpoint, it doesn't matter if there's a plan change. The plan can adopt an SMM and simply attach it to the current SPD, or the plan can adopt a whole new SPD rather than having multiple SMMs. We generally recommend that the plan simply update the SPD and just not adopt a summary material modification, but rather draft an updated SPD, simply because we think it's easier to keep track of one document over several years. If you have several SMMs that are incorporated into the SPD, it may be difficult to continue distributing those to participants or keeping track of them in your files. So generally, we recommend simply updating the SPD if to go.
And last quick question here. Can you just say a brief word about the protocol for plan numbers, ERISA plan numbering?
Yes, so each ERISA plan is required to have a plan number. That plan number is generally required to be included in the plan documents, and that plan number should also match the 5500 filings. So if the plan SPD has a medical plan as Plan 501 and the plan is filed and a 5500 filing is required, then the 5500 filing should also show that the plan is plan number 501. For health and welfare plans, generally the default is to just start at 501 when numbering plans. So if you don't know what number to associate to a plan, or you don't know if a number has been named in the past, generally we just start with 501 for health and welfare plans and move up. So if you have a medical plan, it would be plan number 501, dental plan 502, vision plan 503, and so on and so on. And of course, if you have a consolidated wrap SPD and wrap all your plans into one ERISA plan, then that whole plan would only have one plan number. Moving on to the next slide, after discussing the responsibilities and fiduciary duties that plan administrators have, I just wanted to talk briefly about plan administrator liability. Plan administrators that do fail to fulfill the duties on the previous page may be assessed individual penalties by the DOL or required to repay plan losses. So this is another reason it's important to consider who the plan administrator is, consider who would be responsible in the event that one of the responsibilities isn't carried out, or one of the fiduciary duties is broken. So the plan administrators are potentially subject to penalties or liable in the event of loss. Now, the plan administrator, just because a certain duty is the responsibility of the plan administrator, does not mean the plan administrator is the one that actually has to carry out the duty. The plan administrator can delegate to third parties, and often does delegate to third parties, including TPAs or insurance carriers, some of the duties of the plan administrator. For example, if you are a fully insured plan, you have delegated the duties of claims and appeals procedures to the insurance carrier. Another common delegation of duties is to delegate the COBRA duties to a COBRA third-party administrator. So just because the plan administrator has a certain responsibility does not mean the plan administrator is the one that has to actually handle those responsibilities. There's a big caveat though. Just because the plan administrator can delegate those duties generally does not relieve the plan administrator from statutory or fiduciary responsibility. So if a COBRA administrator doesn't provide a COBRA notice, likely the individual that would be assessed the penalty or sued in that event by the plan participant would be the plan administrator. Now, the way for the plan administrator to protect themselves in this scenario is through indemnification or insurance, and indemnification is by far the more common. In almost all service agreements with third-party providers, you will find an indemnification provision that says the third party, in the event that they don't handle or fulfill their duties and the plan administrator is assessed a penalty, the third party will repay the plan administrator. So the administrator is ultimately responsible for paying the penalty, but they would be repaid by the third-party administrator if the third-party administrator was at error in that case. So indemnification is by far the most common way to protect the plan administrator. In rare cases, normally you would only find it in cases of large self-funded medical plans, self-insured medical plans. It is possible for the plan administrator to get insurance in some cases. Finally, I just wanted to talk about some common ERISA mistakes, so some places where the plan administrator often fails to fulfill their responsibilities, and these common ERISA mistakes obviously relate back to the duties that we have talked about on the last couple of slides. First is the failure to identify ERISA benefits, so that relates to the first slide where we listed all of the potential ERISA benefits, or a non-exhaustive list of the potential ERISA benefits. It's hard to comply with ERISA if you don't know a benefit is subject to ERISA. Most employers know that their major medical plan is likely subject to ERISA. They also know that the snack cabinet that they offer to their employees in the break room probably is not subject to ERISA, but there is a whole host of benefits in between that you want to take inventory of and make sure that you identify them as ERISA or non-ERISA. Another common mistake that we've talked about regularly is failing to file or improperly filing 5500 reports. Also, failing to have plan documents. ERISA has a legal plan document, an SPD requirement that SPD needs to be distributed to plan participants. ERISA requires 33 specific items that need to be included in that SPD, so a common mistake is failing to have that SPD or failing to have all 33 required items in the SPD. Again, as Jason mentioned earlier, following the terms of the plan document is very important and is a common mistake for plan administrators. Sometimes there might be an individual that works close to 30 hours and is not eligible, but for some reason the employer or the plan administrator likes this individual or wants them to be eligible and may want to make an exception, but generally it is recommended, and failing to follow the plan documents and failing to do so is a common mistake. That also relates to the plan eligibility requirements and the next bullet point. And then finally, failing to follow adequate claims procedures is another common mistake, whether that be not providing a reason why a particular claim was denied or not notifying the participant about their appeals rights. So that's basically a summary of some common ERISA mistakes and concludes the substantive portion of the presentation today. Jason, any additional questions or anything you'd like to add?
Chris, we've had a lot of good questions. I think I've taken care of all of them in writing now. Want to say feel free to submit any more questions, by the way, in writing in the question box. And I want to say a brief word about our ProBenefits ERISA services, which are coordinated by Chris, and as you can tell from this and other sessions, Chris does a tremendous job and has a great technical grasp of the rules, but also a good practical grasp of what employers need to know. We take pride at ProBenefits in not using scare tactics with employers as some other voices in the marketplace use, and also focusing on what employers need in terms of practical advice. Most of our ERISA work involves wrap SPDs for employer plans. Most employers use consolidated wrap SPDs these days, but individual wrap SPDs around benefit plans are also an option. And Form 5500 reporting, which, as Chris said earlier, primarily relates to plans that have 100 or more participants in the plan as of the first day of the plan year. Some of you may have read, by the way, about some new Form 5500 guidance that was issued by the Department of Labor about 3 or 4 weeks ago. This new guidance, which is proposed, not final, and also would take effect at the earliest for the 2019 calendar year, would take away the 100 exemption and require all ERISA health plans to file 5500s. That is something we're monitoring. Again, we've got a couple of years to figure it out, and again, that's just proposed guidance. So if you've read anything about that, don't think that the rules have changed for your plans now. We do a lot of work with employers on Form 5500 filing, including delinquent filing for employers that may have some past omissions that need to be corrected, as well as employers who have recently crossed the 100 threshold and need to determine what they need to do. And frankly, we're spending a lot of time with RAP SPDs right now to help employers take care of requirements such as naming the plan administrator, figuring out who that is, getting a document in place so that in the hopefully unlikely event there is an audit, or in the event that there is a dispute with a participant over eligibility, claims, premium payments, etc., that the employer will be able to rely on the formal summary plan description and plan document in order to protect its position. So know that we're available as a resource to you. Chris coordinates those services for us and does an excellent job. Thanks for joining today. Right now we're going to go ahead and wrap this up. If you have any more questions, feel free to submit those through the question box, or you can email Chris directly at christopher@probenefits.com. Thanks, guys. Have a great day.